What just happened at the Supreme Court is massive and almost nobody's talking about it. An 8-1 emergency ruling just came down that completely changes how Second Amendment battles play out across America. And here's the twist. This isn't a simple win or loss. It's something way more complicated and way more important for your gun rights. By the end of this video, you'll understand exactly what this means for you and your Second Amendment freedoms. So, let's dive in. Before we start, hit that subscribe button and double check you're still subscribed. YouTube keeps unsubscribing people from channels like mine. If this content matters to you, smash that like button too. The Supreme Court just denied emergency review in one of the most critical Second Amendment cases you've probably never heard of. This involves something called a SAPA law, Second Amendment Preservation Act. What's a SAPA law? Simple. It's a state saying, we're not going to help the federal government enforce gun laws we think violate the Second Amendment. This matters because federal agencies rely heavily on state and local law enforcement to enforce federal laws. They don't have the manpower alone. When a state says we're not helping, it creates a massive problem for federal enforcement. Missouri passed their SAPA law in 2021, and they went Allen. The law said, Missouri defines the Second Amendment our way. No state resources or personnel for enforcing unconstitutional federal gun laws. State officials can't help federal agents enforce laws that violate two. Citizens could sue state officials who do help. That last part is huge. Missouri gave enforcement power directly to citizens. If you saw a state cop helping federal agents enforce what you believed was unconstitutional, you could sue that cop. But the Biden administration immediately sued Missouri. They argued, you can't refuse to help us. This is obstruction. A district court agreed and struck down the entire law. Missouri didn't back down. They appealed and asked for a temporary stay, basically saying, let us keep this law while we fight. The lower court said no. So Missouri went straight to the Supreme Court for emergency relief. This is rare and serious. You only do this when fundamental rights are at stake. And here's what happened. The Supreme Court voted 8-1 to deny Missouri's request. 8 justices said, we're not stepping in right now. Only Justice Clarence Thomas stood with Missouri, the same justice who's been the most consistent Second Amendment defender on that court. He was the lone voice saying, wait, we should look at this. But he was outvoted 8-1. Missouri went back to the circuit court. They held expedited hearings, and once again, the court ruled against Missouri, striking down the SAPA law entirely. But here's where it gets crazy. The circuit court admitted the structure of the law might be constitutional, but they struck it down anyway because they didn't like its Second Amendment purpose. They essentially said, we don't like that you're protecting gun rights, so your law is gone. Even wilder, the court said Missouri officials were enforcing the law by simply not helping the feds. Non-action became action. Doing nothing, literally choosing not to help, was somehow the same as active enforcement. Missouri argued this made no sense. How can we be sued for enforcing a law when we're just not doing something? But the court didn't care. Now, here's where it gets interesting. This lawsuit started under Biden, but then Trump took office. Everyone was watching. What will Trump's DOJ do? For months, they stalled. No response. People were frustrated. Finally, the answer came, and it was complicated. The Trump DOJ told the Supreme Court, some of Missouri's SAPA law is probably invalid, but the lower court went too far with a blanket injunction against everything. Then they made a crucial promise. If you deny review and send this back to the district court, we'll release parts of the judgment. We'll let some of Missouri's SAPA law go into effect. This is significant. The Trump administration was saying, we're not fighting all of this law. There's a middle ground. They mentioned the anti-commandeering doctrine, a constitutional principle that says the federal government cannot force states to enforce federal laws. They believed some of Missouri's law might be protected under that doctrine. Missouri responded, you just admitted the lower court went too far. That's exactly why the Supreme Court should review this. It was a good argument, but the Supreme Court didn't buy it. 8-1, they said no. The case goes back to the lower court. So, what does this mean for you and your gun rights? First, This case is not over. The Supreme Court just said they're not intervening right now. That's different from saying Missouri's law is unconstitutional forever. The Trump DOJ promised to release parts of the injunction once it goes back to district court. That means some provisions of this law could actually go into effect based on their filing. They'll likely allow the non-enforcement aspects. That means Missouri officials won't be required to help federal agents enforce certain federal gun laws. They can say that's your job, not ours. Will it stop federal enforcement? No. The ATF can still operate, but they'll have to do it without state help, without local police backup, without state resources. And that matters because federal agencies rely heavily on that cooperation. Here's what we're about to find out. Will Trump's DOJ keep their promise? Which parts of the law will they allow? Will other states follow Mizzou's lead? Because Missouri isn't alone in watching this. States across America are asking, can we pass a SAPA law? Can we protect our citizens' Second Amendment rights? If Missouri's law survives even partially, it creates a precedent. Other states will follow. We could see a wave of Second Amendment sanctuary states refusing to cooperate with federal gun control. The anti-gun lobby knows this. That's why they fought to kill Missouri's law completely. They didn't want it narrowed. They wanted it obliterated. But now the door is cracked open. Not wide open, but cracked. And that's hope. This isn't just about guns. It's about federalism, the balance of power between states and the federal government. The Founding Fathers designed separate sovereign levels of government. The 10th Amendment says powers not given to the federal government belong to states or the people. The Supreme Court has recognized the anti-commandeering doctrine before. In Prince versus United States, 1997, they said the federal government can't force local law enforcement to do background checks. Justice Scalia wrote the feds have to enforce their own laws with their own resources. So why is Missouri's law controversial? Because critics say Missouri isn't just refusing to help. They're actively interfering by penalizing officials who cooperate and declaring federal laws invalid. Missouri's response: we're not nullifying federal law, we're just not helping enforce it. The feds can still do their job, they just have to do it themselves. It's a nuanced argument walking a fine line between state sovereignty and potential obstruction. And here's why this matters beyond guns. If Missouri wins, it opens the door for states on all issues to say, we won't help enforce laws we think are unconstitutional. That could restore state sovereignty and limit federal overreach, or it could make federal law unenforceable in certain states. That's what's really at stake, the entire structure of American federalism. This case goes back to the Western District of Missouri. The district court will process the Trump DOJ's promise to release part of the injunction. The judge will decide which parts get released, what can Missouri enforce. But remember, this judge already ruled against Missouri once. So, there's no guarantee they'll be friendly now. Even if Trump's DOJ is more accommodating, Missouri will have to carefully implement whatever they're allowed to enforce. Because the moment they start, someone will challenge them again. The big question, will this eventually come back to the Supreme Court? Because this was just an emergency review denial, not a ruling on the merits. If there's a final judgment in the lower courts, Missouri could appeal back up to the Supreme Court. And Justice Thomas already showed he's interested. He might persuade other justices to take it at that point. So, there's a path for a landmark ruling on whether states can refuse to enforce federal gun laws. It's not guaranteed, but the path exists. This 8-1 ruling isn't the end. It's one chapter in a longer story about your Second Amendment rights and federalism. Is it a win? Partially, the Trump DOJ promised to allow some enforcement. Is it a loss? Also partially, the Supreme Court refused to clarify critical questions right now. But the fight for the Second Amendment never ends. It requires constant vigilance. What Missouri is doing matters. They're fighting. They're not accepting federal overreach. They're using every legal tool to protect constitutional rights. That should inspire you. Ask your state legislators, will you stand up for the Second Amendment like Missouri? Will you pass laws protecting our rights? Your rights are only as secure as your willingness to defend them. The Second Amendment doesn't protect itself. Pay attention as this case develops. Watch if Trump keeps his promise. Watch if Missouri defends their law. Watch if other states follow and stay engaged. Contact your representatives. Support organizations fighting these battles. Vote for candidates who take the Second Amendment seriously. If this video helped you understand what's happening, hit that like button, subscribe, and turn on notifications for updates as this case develops. Drop a comment. Should your state pass a SAPA law? Will Trump's DOJ keep their promise? Share your thoughts. Share this with friends who care about the Second Amendment. Most people have no idea this case exists. Remember, your rights don't protect themselves. Stay informed, stay engaged, and never stop fighting for freedom.